Again, thank you everybody for joining in for today's session. Today's workshop is on the basics of international law, international relations, and criminal justice for debating. My name is Kaushik, and my experience has been for quite a few years in terms of the debating space, and it's a pleasure to have all of you join us today for this session as well. And thank you for all of the members of Ignite for having me on board. I am one of the cores for this edition of the tournament, and it's our pleasure to have these particular workshops hosted for all of you. And the initiative of the entire Ignite team and OC is something which is phenomenal for increasing the access to resources and availability of materials. So we won't take a lot of time, and I'll quickly go through the material today. I'll keep more time for questions at the end of the session so that everybody can have their doubts cleared today. So why are we essentially doing this workshop and what are we going to cover? So often it's been seen by me personally and also by people that I've been speaking to quite often that in debates there's often an argument where people don't really analyze what essentially are the ambits of what a state should be doing. There's always confusion about what are the realities of how states operate in international relations or in terms of how states operate in terms of discussing things between states or within states as well. And also on the same line, how criminal justice systems occur in terms of the way in which they are supposed to in common law systems. Of course, there are outliers like anarchies and autocratic nations where you're not going to have the same principles of criminal justice apply. So we are not really going to be dealing with issues like that. We are going to be talking about what essentially are the fundamental concepts under international law that you need to be careful about when you're debating. What are the concepts under international relations that you need to be careful about when debating? And also, what are the concepts under the criminal justice system or law in general that you need to be careful about in terms of how states decide what punishment should be meted out to certain individuals or not, and what kind of relationships do different aspects have. So these three essentials, like international relations, covers the why and explains what the motivations of the states and the behaviors of the states are in terms of their interactions with each other. International law defines the rules of that interaction and what are the applicable legal principles and barriers that govern states. And criminal justice systems are often systems where how law is maintained within a state itself, like the models of how punishment is dealt within the state and what crimes are understood to be within states. So the next consideration is that what are essentially the values of these three ambits. I think a that we will be facing a lot of like motions which are going to be dealing directly with criminal justice, international law, and international relations. So that's the fundamental aspect as to why you're going to be listening into this workshop to begin with. But I think there's also like a lot of nuances which are often mistaken, and I think this workshop would be something that is going to be helping you deal with a strategically thinking about different motions and motion types with relations to international law and how states interact with each other, as well as the criminal justice systems, which would enable you to unlock a lot more ideas as to how to build your own arguments. So, what I will be doing throughout the session, as we also did yesterday, was that I will be giving you principles, I will be giving you examples in terms of how those things are operative within, say, some example motions, and how you can think critically in terms of applying these three areas towards your debating and how you can prep better in terms of these particular areas as well, understanding what these concepts are. So, diving right in. So, part one, we are going to be dealing with international relations or the why as to how states monitor each other, govern each other, talk to each other, and converse with each other, and what are the principles that are underlying in terms of the relation that states have within, say, different regional contexts and all. One caveat that I will be giving you before like beginning the three parts that we're going to be discussing today. This is again somewhat of a beginner to an intermediary workshop where you will often not find that much depth into learning exactly the entirety of the concept, but we will be giving you the bedrock in terms of understanding what those concepts are, and at the end we'll also be discussing what essentially judges should need to do in terms of like analyzing law motions or international relations motions or international law motions. And I hope that at the end of the hour or so or hour mark or so, you will have something that you can take away from this workshop, which is beneficial to you over the 3 days or 4 days of the events. Right. So, diving right in, international relations. The first concept that we'll be discussing within international relations is anarchy. So, anarchy in IR does not essentially mean anything chaotic or anything which is unprincipled or undefined or the absence of multiple things. It means solely an overarching world government or world police is not present. What we mean to say is that each states have their own jurisdictions, each states have their own law, and each states have their own like necessities which they exist within, which means that there is always going to be some amount of like dissonance into what those states would want to do in terms of what they are and what they want to achieve. What I essentially mean by this aspect is that states have their own um, merits that they want to promote, and they have their own like systems that they want to keep and their own systems that they want to protect. So what this inherently does at the end of the day is that it helps to maintain the interest of the states itself, which means that often or not, when you're looking at the entire global picture, the states won't be operating in the guise of what the global picture would be better dealt as, or how, what would be the benefit to the global world order. And the problem therefore becomes that there's often like a lack of enforceability of different decisions that come around in international forums, which will be something we'll be discussing when we're discussing the UN as well. And therefore, if there is no higher authority to enforce rules or punish bad actors or guarantee a state survival, there's often a lot of points of conflict which can occur between different states. And those points of conflicts are essentially where often you will find a lot of like debate motions stemming from. And that is something that you have to be very careful about. So, for instance, if there's a debate motion which is comparing an actor's like the United States has different like relations with different parts of the world. With Europe, it has much more friendlier relations than probably with say India or China or so many other countries which has often had conflict within the past in terms of those particular decisions or systems that these particular countries exist within. So what it means is that each state would have prioritizations of certain things which they prefer in the global order, and that would inherently mean that there is no reason for them to enforce things which are not beneficial to them or mold themselves to the idea of other states in terms of how those states are operating if there is no benefit for that particular state to have that thing operating within their own country. So the easiest way of defining why this is so is that every state has to look after its citizens and it has a responsibility to be re-elected. It needs to like serve or cater towards the citizenry. So every thing that they do is basically based on the idea of self help. And every IR argument flows from this fact that every state has some core interest or some principal things that they prefer. Like US would always be democratic, Europe would also veer towards democracy, Russia would gear towards communism or say autocratic democracy systems, however you want to define it. China would gear towards communism, Vietnam would gear towards communism, and that is something that is always going to be a fact. And if the realities of the states are dealt upon in certain ways, it is always going to be important to consider that the states would act towards other states on the basis of how those states are operative and what are the principles that those states prioritize. So, a democratic institution like the United States has often been seen in the global world order to obviously go ahead and be like this overarching big brother figure that comes around in the world, if for the lack of a better term, where US has often gone into different countries and been the salvation army in you in the way in which you can see in Afghanistan and you can see in the Vietnam conflict and so on and so many other conflicts as well. So there is always like certain incentives that certain states follow. Now, of course, we cannot discuss how every state can or what are the incentives of every state. The only like thing that I can tell you in terms of improving your knowledge base on this is that if you go ahead and read from certain sources about basic principles of how like states operate globally, I think you would find it a lot more valuable to go through the internet to read about those concepts because of course IR, IL and CJ, criminal justice, international law and international relations are vastly like big subjects. It's not very easy to deal with at any point of time. So you will always have to constantly be reading a bit about that as well. So reading on those ideas would also give you like a concept about why there is distrust between certain states. Like why does America distrust China so much? Why does China not like say people in the South China Sea like Philippines and so on? And why do they want to go ahead and want to gain more like for instance territories and so on? So those are the particular things which is very important in terms of understanding how those states would act and what kind of like build up you need to make in terms of model and framing for different types of motions. Now when you are looking at state interests and this idea about why those states are operating, this is also the way in which you're approaching how to tackle like arguments which are contradictory or not really well reasoned in terms of how the states are operating within the larger perspective of the world. Now, that being said, anarchy is one of the basic things that we'll be dealing with. But the first theory that is really probably beneficial for you in terms of international relations is realism. So, realism indicates that states are the only actors that matter, where they are rational, self interested, and with the intention of surviving and having some amount of power to like promote their own interest and perceive that their own interests are met in the global order of things and in the global communities that that state is represented in. So this would simply mean that in terms of considering morality, ethics, or what this essential actor would want to do in the broader scheme, or what these particular responsibilities of these actors are towards other states, there's no real consideration. It's only that the leaders of these states are duty bound to protect the state's interests, which means that there's no real reason for them to promote anything else that comes around. So, this can be an important consideration here. An example could simply be that if you're talking about international institutions, which would be often a very key factor of many debate motions, international institutions have participation from different states. Could you please mute yourself if you're unmuted right now? Right. So, if you're talking about these particular international institutions, like for instance, the United Nations, there's always going to be differing interests from different blocks, and there's no real like consideration of what the other states' interests are in terms of promoting your own country's ideals. So, this is where the concept of realism is sort of like applicable, where a leader's duty would be to only protect their own interests and what those states want to do. Like Trump is currently like promoting very heavy tariffs across the board. The entire idea is that they're trying to protect the United States interests in the global economic order and wanting, and the bedrock of that idea is that it should be something that is protecting the state interests of America. But of course, the application is much more complicated. It's not always going to be at the end of the day practically beneficial, so those things can still be argued out upon. So it's an interesting thing to think about. Now, what realism essentially is a tool for talking against interventionism. So why would states inherently intercede with the actions of other states? For example, if you're talking about a motion that is dealing with Myanmar, Myanmar is a place which is currently embroiled in a lot of conflict. Another example could be Bangladesh, where there was recent protests. Another example could be Sri Lanka, where there were protests as well. In African states, also, there have often been conflicts like during the apartheid movements or other things. So the question then becomes simple as to why you, in some concerns, some states are going to be interventionist, which means that states would try to act in the interests of preserving a good world order by intervening in states with a lot of conflict. This could simply look like, say, sending maybe peacekeeping troops or becoming part of diplomatic dialogues like Qatar does and other countries do in terms of proliferating peace between different states and different regions. And I think that is where this concept sort of like talks about why those states would not be someone who is prioritizing others' interests over their own. So even if you're going to go ahead and look at these particular conflict points and institutions or organizations or countries who have often like worked towards like dealing the best kind of like interest for the global world order, the simple consideration here is also that the argument against it is that at the end of the day, even if somebody is interceding, their own primary interest, if they are harmed, the states would prioritize their own primary interest over the interests of the other states that they're trying to go ahead and deal with when they are dealing with like peacekeeping meets or dialogues, which essentially happens between different nations and countries. So that is how you can sort of like build into the concept of, or build from the concept of realism into your debating arguments and how you like factor in different ambits of conversations around it. The second IR theory is liberalism. So, liberalism means that cooperation is possible within the states. States are not really isolationist, even under anarchy. States can achieve mutual benefits by cooperation. This is something that is predominantly seen in things like globalization, where if some states are producing some things, or maybe some states are resource intensives and have better benefits in terms of producing those resources, but some states are maybe service oriented and can provide a better service or quality of service, then those states can cooperate and have mutual benefits by sharing those resources across those forums. Now, how do these things work out? Usually through international institutions like the United Nations, the WTO, or maybe dialogue between different states, and regional like groups like ASEAN is a good example from my region, and there are other like examples as well. I'm forgetting the African one that I had in my memory before the session, but yes, the congregation of different states, if they come around and sit and talk in multilateral forums where multiple states are coming around and speaking about issues which are common to them or important to them, those bodies can look at, say, mutual benefits and preserving the requirements of each other. Now, what is the problem when you're looking at realism versus liberalism? Let's look at it from the ambit of certain motions, right? Let's look at the first motion. This house would strengthen the UN. Now, in a realist framework, you could simply say that the UN is a useless body. It doesn't really do a lot of things. It takes up a lot of resources. It has no real power because it can't really do any actions against member states, as we have seen in the past. Only states and armies have power, and therefore it's not really going to be very important. But in a liberal framework, you can look at the same perspective from look at a different perspective from the same, like for the same body, and you can say that the UN is probably like a critical place for different discourses and different exchanges, and also a forum for diplomacy. It also brings around a lot of important conversation points about different places of conflict or different issues that people have often faced or have faced. And it can prevent state to state conflict by discussions, or it can prevent harms that can occur by building trust between different states, or give a platform for different places or regions to have a conversation point from. So both of them are talking about the UN and UN's application and how the strengthening of the UN is something which is important or not. But both of them are approaching them from two different considerable points of equal benefit or harm that can be there, and it needs to be proved through impacts. Another motion, if you could look at, if you would say that this house would sanction nation X, like from the realist framework, you can simply say that sanctions often have a tendency of failing. A good example of this would be Russia, where the sanctions didn't always like help out, and they could say that nations rival could simply fill the gap because it is in their own self-interest. Like for instance, a lot of conversation has been made about um, goods which flow from sanctioned countries to other countries via third-party countries, or countries who are like purchasing those goods and commodities from sanctioned states who they have not sanctioned, and then selling it back to states which have like sanctioned these states for acting like an intermediary between them. On the same end, for a liberal framework, you would probably see that sanctions can create an international norm and can isolate certain problematic behaviors or tendencies, and can also lead to cooperation between different states in calling out certain people who are problematic in the world, leading to efficient change or efficient benefits. So there's of course much more depth and detail that you need to go into. These are just like first layer of statements that you would probably exploit when you're dealing with talking about these issues from these two frameworks. We are not going too much into depth as to how these things would realize their claims. It's just how those claims can look like in those particular paradigms for these motions. Now, what are IR actors? There are multiple types of IR actors. We have only discussed states much more than we have discussed anything else, and a bit about international institutions. But if you're just talking about states, you have to be considerably fault. Your argumentation would be considerably faulty, because states are not solely participating in international forums, and states are also not the sole signatories or beneficiaries, probably, or conversation points in international forums and international dialogues around IR and so on. There are also non state actors like international governmental organizations. States are members to these organizations, and we have discussed this in brief, like the UN, NATO, EU, World Bank, and they have institutional powers. The second ambit beyond states are NGOs or non governmental organizations like non-profits, private groups like Amnesty, International Red Cross, Greenpeace, and so on. They have soft power, which means that they have the ability to name and shame, provide statistics and data, and can be looked at with more moral legitimacy than others, particular actors. And lastly, there are multinational corporations, or people could know them with different names, international institutions, and so on, or international companies. These are basically for profit companies like Google, Shell, or Amazon. They have economic power. Another good example is NVIDIA in the world of AI. This economic power means that they have significant power to lobby in the states that they're present in. A lot of economic policy and changes can occur, and conversations can change between different states when a very good, high positioned multinational corporation is at stake. For instance, if there is a conversation between like two states on the value of um, free trade agreements, when there's a lot of like cooperative nature between states, like if there is a oil producing state in South America or Africa and Shell has gone ahead and invested in that state, there's a lot more potential that cooperation between, say, America, the place where Shell is based out of, as an hypothetical example, and that particular country where Shell has probably invested to make that market more sustainable would be easier. For instance, that particular country would have an easier or conversation point or a much larger persuasive need from, say, countries where these particular corporations are based out of. Now, you can use IR actors in different ways. They can be used to critically look after, like criticizing different governmental policies or models which have been brought around by the proposition framework. You can also use NGOs and MNCs to discuss about how media perception occurs in different international relation issues, why that is much more likely that governments would be persuaded by those particular disruptions and therefore make changes. You can also argue from the idea that why does MNCs and operations of MNCs help those particular countries grow. So you can use these particular actors or non-state actors in terms of different fabrics of motions by implementing what kind of use cases those particular non-state actors have in terms of moving the needle forward in your model or your policy. So that's how you can use them in debate spaces. So yeah, that brings us to a close of the basic brief about international relations. The second thing that we'll be talking about is international law, which is the rules which make the states operate with each other, or what are the obligations that states have to each other through legally accepted terms, or what people have bound themselves to by like subscribing to a law. Now, the core concept of international law is based on the idea of sovereignty. Sovereignty is the principle that a state has absolute, exclusive, and supreme authority over its territory and people, free from external control. Now, sovereignty is something which is a very important ambit of tool that is used for debating, and I think it is a simple principle to also understand itself. Sovereignty is important because you can't compel states to make actions when those states have their own interests to conserve. You can't dictate that states would be taking certain actions when you cannot prove that that particular state is benefited from the action that is to be taken. So this means that if you're critically arguing from any perspective of the government becoming better or the governance becoming better, or maybe the operation of that state improving in that paradigm of any motion that you're debating, you have to always tie it back into the idea that a state is sovereign. There might be problems in terms of interventions occurring within the state where you are detracting from the sovereignty of the state, which is not something which is cohesively looked well upon in terms of international bodies or international institutions or even countries across the globe. Usually, sovereignty is something which should not be exploited or should not be taken advantage of. And that can also lead to a lot of like critical analysis on how states would respond to claims of land or claims of sanctions against them or something around that line. For instance, if you're taking examples of Russia or you're taking examples of China and the sanctions that occur within these two particular countries, they have their own interest to maintain first and foremost, and they have the right to do whatever they want to do within their own territory. So your sanctions can only stipulate your exchanges between states to be stopped it cannot really intercede as to what that state itself wants to do within its own territory. It has complete authority and rights to do so. Now, this is also the idea which is where the UN system is based, and it is dealt with in the UN Charter as well. This is what prevents country A from invading country B just because they disagree. So there are certain like agreements that basically states have where people should not alter borders and so on and so forth. And this that particular group of arguments are important to consider in terms of how international institutions are respected and working, because that is also what give them the legitimacy and that is what the reason of these institutions existing is. So there's a fundamental conflict between international in international law rather. The conflict is discussing the right of the state versus the rights of the individual or human rights. And why is this something which is important? I think this is something that you will find more so in debate motions around like coups, rebellions, uprisings, and so on. And how do you preserve the conversation about states when you're talking about issues like that? So this will always be like a balance of probability between the two things. And that is where you also discuss that where are states supposed to intervene and when is it right for different particular states to act out against other states in the first place. Now, R2P or responsibility to protect is like a global norm that came around in the 21st century, which discusses the attempts to solve the sovereignty versus human rights clash. So, there are three pillars that essentially are important to consider. The first one is that the state has the primary responsibility to protect its population from genocide, war crimes, etc. You would have often seen that there are motions around genocide, war crimes, and all. Now, if states fundamentally fail upon their primary responsibility of protecting its population, that's one place where the human rights perceive over sovereignty and what state can act as like a legitimate power. The second pillar is the international community also has a responsibility to assist the state. So, if, say, there is aggression against a state, the international community should volunteer to assist a state against aggressors of its sovereign rights. Now, if there's a legitimate like claim in terms of conflict between two states, like country B has violated the rights of country A and has interceded upon its border and gone ahead and entered its borders without any right to do so, then there is a obligation of the international community to sort of go ahead and help out the country which has its borders encroached upon. And the third pillar is if the state fails to protect its people or is the perpetrator of these crimes, that state's sovereignty is forfeited and the international community has a responsibility to intervene. This is essentially the discussion that had occurred a lot more in, say, early 21st century in terms of the global war on terrorism. But it also discusses a lot of different aspects like when is it right to intervene or to send help to a state or to intervene in the policies of a state, or when is it right to do something. And this is the claim that you justify in terms of a principal argument in debates pretty often, right? So if there is a motion like this house would intervene in Ukraine as the European Union, it could simply mean that you're looking at the sovereign interests of the country. The country has the responsibility to prevent war crimes and genocide to happening to its population. If it is failing to do so and wants assistance, the international community is obligated to provide that assistance and intervene if necessary. And that could be some of the ways in which you can look at how interventionism is allowed or legible in terms of different states' claims, which are not like the sovereign of that state. Now, the problem here, however, is that IL is very fickle. International relations, international law are chambered in a lot of like problems, and they're not easy to alleviate these problems. The problems are much more deeper than we can probably imagine. The problem lies on a couple of folds. One is that there's no really claim of world police, and trust me, Interpol and other places where there is a semblance of different cooperations between states police systems, they are still not like a world policing organization or a world policing body or a prison that the world holds, where people like criminals of a bad nature who have committed crimes against multiple states can be held. That's one weakness of international law and international relations as an extension. The second weakness or the second problem is that, or which is a direct relation towards this first aspect that we discuss, is that enforcement is often problematic. Now, you would have noticed that there are, if you would have read international law previously, and for those who haven't, the UN has something called the UN peacekeeping forces, and interventionism from UN peacekeeping forces to prevent war crimes and to maintain order in states is fraud. Is completely fraught with a lot of problems and challenges because one, the potential big five or the five permanent members of that particular UN Security Council is problematic in general. So the UNSC is the only body that can legally authorize coercive action in any state, like sanctions or military interventions. Now, if they are the only body that can legally authorize this from like an international institution perspective, like the UN, the problem is that if the P5 or the permanent five, as we call them, which is the US, UK, France, Russia, and China, ever veto any resolution for any reason, that means that particular authorization or course of action is often not taken. And the reason why this is more problematic is because a lot of states have cooperations, agreements, or relations with either of these particular five states, which means that if China is doing something wrong, or if somebody who is allied towards China is doing something wrong, or if Russia is doing something wrong, or somebody allied towards Russia is doing something wrong, they can easily like veto any plan to take action against them. Now, how does this veto system work? And it is something important to consider because we are discussing international law in general and how the UN operates. The all five members get a vote, and of course, all five members can veto unless all five agree together that something would be done. Nothing would be done by the UNSC essentially, which means that all states in that particular list has a veto power, and if any of those states veto it, that means that no action is to be taken. Now, initially, of course, this was created to prevent harm towards the global order and towards global peace, but it hasn't always like lived up to what it intended to and what was the principle the UN wanted to. So that is the biggest dichotomy that you would see in the presentations of how UN operates in the global order. And this is something that is also critically important when you're looking at motions around efficacies of the international institutions and international bodies. So this is one ambit of how you can probably debate around that. Now, the other aspect is the other aspect of the enforcement part is the law um, interpretative process or the courts itself of international law. There are two fundamental institutions called the International Court of Justice and the International Criminal Court, the ICC and the ICJ and the ICC. Now, who are the people who approach the ICJ? So, ICJ is approached when states have conflicts with other states. The International Criminal Court is approached when individuals have committed heinous crimes, basically. There's a threshold of what crimes are to be considered under the International Criminal Court. So these could be like generals, presidents, militant group leaders, terrorists, and so on. While in ICJ, states are the only people who approach. They're not like individuals filing cases against each other. Now, what are the functions of these two? The ICJ deals with disputes between countries, like where is the border, where is the economic zone, where are the how water sharing should occur between two states, so on and so forth. But in International Criminal Court, people are prosecuted for heinous crimes like genocide, war crimes, or crimes against humanity, as they are said. Both have problems. Now, in ICJ, you can't compel somebody to participate. It does not have any enforcement mechanism. The UNSC veto still creates a problem. Both states need to agree to come to the forum to adjudicate the matter before the forum. Even if the forum comes to a decision, both states need to legally, like, for them to have like implications or applications of that particular decision, both of them need to consider that they are actually the ones who are willing to abide by the law that is passed by the ICJ or the judgment that is passed by the ICJ. Sorry. So it's often problematic for ICJ enforcement to occur because states can just simply say, "Oh, I don't want to follow the judgment because it is unfavorable to me and I have lost this case." So there's often problems that can occur between institutions in that sense. Now, in ICJ, that occurs, but in ICC, the problem is different. In ICC, it's always victor's justice. Like major powers, US, China, Russia, have not joined the ICC. Even many countries have not joined the ICC. So the ICC, first of all, does not even have any jurisdiction in prosecuting different individuals from these particular countries. But often or not, the definition of who is a criminal is very subjective towards what the state dictates it to be, and that becomes a huge problem in terms of analyzing what kind of individuals are tried in the International Criminal Court. Now, again, let's go back to the last slide and think about this. If there is no like policing body or mechanisms to hold perpetrators to justice, and if states don't willingly cooperate, usually what happens is perpetrators can flee their own countries and take asylum in other countries where they are not obligated to hand them over to the ICC or so on. And that becomes a huge concern itself. So it's a very interesting read. If you have time, go back and do read that as well. Now, utility of ICJ and ICC is basically in discussing different aspects of state disputes or human rights violations, of course. So that brings us to an end to the international laws brief. Now let's look at the law and criminal justice systems and what are the models associated with them. So the core clash of criminal justice systems or law in itself is retribution versus rehabilitation. This is usually what all debaters should prioritize and focus upon when they're doing law debates. Like the objective of law is either to give retribution or to rehabilitate different differences in terms of how criminals are approached and taken care of in different systems. So retribution means punishment. So the goal is to simply dispense justice or to punish somebody who has committed a wrong in the past. Now, the reason that retribution initially started out in the world is to ideate that there is certain social responsibilities that individuals have within a community, which means that you have obligations to operate within the community space with their set rules and their set regulations. And in violation of that set regulation or rule, you are committing a crime against the community itself. Now, the seriousness of that crime or the seriousness of the harm is something which is defined by the state itself, like constitutions of the state and laws of the state usually define what are the problems that are acceptable to be leveled as punishment crimes, or what are like general misdemeanors or civil problems like marriage or divorce and so on. So the idea for retribution is that crime usually creates a debt to society, which means that you have done something which is wrong and you owe the society something for committing that wrong, which is often or not punishment. Now, retribution is often retrospective. What this means is that you can't provide punishment for people who have not committed a crime. So, in any case, whenever you are looking at a legal system, punishment is always associated with past committing pasts or past incidents where commissions of the crime has actually occurred, which means that it is a backward looking thing where you are giving retribution as a retrospective analysis of some wrong which has happened in the world. And rehabilitation, on the other hand, is correction. So, rehabilitation could be the idea that you have to fix the offender and prevent future crime, which is the reason why people are sent to jail. So, the jail serves a duality of purpose, that you are giving them a punishment, but you're also like rehabilitating them to prevent them from committing the same crime again. Now, there's always like a critical aspect to look into. There's always like conversations around psychology, psyche, sociology, and everything around in terms of how the operations of crime occur. If we go too much in depth into what these particular aspects are, it will be like a 2 3 hour workshop, and we'll still not finish. So, just to be brief, there are certain philosophies in the world where people think about what is the mindset of criminals and why people are essentially forced to commit crime. An example of this could be that if somebody is suffering from abject poverty and they're extremely hungry, the person might choose to then go ahead and commit a crime to feed their family or to feed themselves, by stealing maybe a loaf of bread. So, usually, why this is an important consideration of discussion here is that there is an aspect where people talk about the psychological issue of crime, or what the responsibility of the society is to the individuals to provide education, to prevent crime, to provide therapy, to reduce recidivism or reoffending or committing the crime again, and how you can prevent these aspects. Community also has a responsibility that it is also like a social phenomena that the crime has often occurred. So certain proponents have this idea that crime is a reflection of society, or crime is a reflection of how different perceptive values of individuals have grown or changed as they've grown up, or what are the psychological growth hampers that they've faced for them to commit crime. Now, of course, this is a discussion that can go on and on and on, but on the gist of it, there are certain ways in which you can debate these particular aspects. You can look at how the crimes commission can be a not necessarily the fault of the actor per se because of other factors. You can look at it from the idea that a crime can be a justified crime. You can act, you can discuss aspects like a crime can be labeled as a crime, but it should not be labeled as a crime. It's a crime because somebody who had too much power has decided it to be so. So these are aspects that you can consider when you're looking at different aspects of legal systems. And there are, of course, different like trajectories that you will be discussing these criminal justice theories from and say laws from. The first criminal justice theory that makes any sort of like requirement in terms of debating is deterrence. So, deterrence is this idea that we can punish one person to protect the others by giving them an incentive to not commit the crime or the same crime, by saying that, right, we will punish you if you commit the crime, which is why the commission of the crime is something that you really should not be doing. And the deterrence is, of course, of two kinds. One is a specific deterrence, like punishing an individual to stop them from doing it again, like punishing somebody who's like probably a murderer or somebody who's done some grave harm to society. By putting them in jail, we are deterring them from committing the crime again. A general deterrence is punishing an individual to stop other people from committing this. So it would often be that you would see people like parents or maybe education or any form of discussions between like members who are discussing crime or social harms or evils. They would say that, Acha, you don't need to do this because if you do this, you will be labeled a criminal. This is wrong to do this. So that is the aspect of deterrence that is essentially what punishment is trying to achieve. The second theory is the broken windows policing. So, this theory means that if there are visible signs of public disorder like graffiti, broken windows, and so on, um, they're, they are signaling that no one is in charge, and it means that the state has failed in preserving law and order, which can invite more disorder. And then, if it invites disorder, it can seriously escalate and start becoming like more serious crimes at the end of the day. So, what essentially it means is that if there is a broken window, or if society is failing in small aspects, it can eventually keep escalating or keep growing to a point where more commission of crime is possible, or there's a larger possibility of recidivism and other issues that come around in terms of problems in society. Now, broken windows and the serious crimes can both be symptoms of a third deeper cause like structural poverty, systemic disinvestment, and lack of opportunity. So, these are also places where you debate different issues of crime and punishment from. You have to look at things like structural issues of poverty. You can look at things like systematic disinvestment. You can look at things like opportunity problems and costs and so on. Now, you can then utilize this to attack the symptom. Like if there is structural poverty, which is the reason of people committing crimes like stealing food, you'd probably say that it's better that the state prioritizes upliftment of poorer individuals of society, which is attacking the system and not the disease. You can also like discuss counterproductive nature of different policing mechanisms, which could simply look like criminalizing poverty or punishing homeless people or destroying police legitimacy in minority communities and so on. Now, what this means is that if communities hate and fear policing, They can also be indicative that they are going to go ahead and stop cooperating and stop reporting a crime and making the community less safe. So these are all methods in which you can apply yourself towards different like legal motions and think about productive ways in which you can argue your essential points. Now, what is the framework of social issues that we discuss? I think the first aspect of social issue problems that is important to consider is what is the root cause or root nature of different harms and different benefits that are proclaimed in society. I think social issues is something we touch upon in the previous slides a bit too. Social issues could simply mean things like poverty, things like growing up in a particular family which is much more like attuned to criminal activities than positive activities in the society, or maybe growing up in the ghetto, as they call it in American and media uh, lore. If you grow up in the ghetto, it's much more easier to grow up in a place where you are a looking at crime much more often, but it's much more likely that the crime commission of the crime is one of the few ways that you have to live in that particular city and state. So, social issues can also be a good bedrock for discussing different problems or root causes of issues, which can be discussed in terms of debate. Now, how do you look at it from the policy perspective? The one thing that we have not discussed yet is how the carrot and stick approach can work. You can take action in two ways. When you're building policy and you're building your model for your debate, there are two ways which you can take action from. One is that you're incentivizing the non commission of crime, or you are punishing the commission of the crime itself. So the stick approach is usually the punishment, and the carrot approach is usually rewards, which is associated with non commission of crimes or something like that in terms of a criminal justice system. So you can use these two perspectives in terms of promoting what kind of like different challenges and issues that can occur within that. So let's practice a motion. I will be reading this out and then taking it down a bit. This house would militarily intervene in a sovereign nation to stop a genocide. Now, this deals with multiple concepts. One is interventionism, one is sovereignty, one is states' responsibility and state authority, and one is also war crimes and the utility of ICC and other particular states in terms of genocides. So, what you can argue is that a military intervention is just when people are losing lives, and it is much more important from R2P. It is more important to consider like the important considerations of how people or human rights of people are conserved rather than the rights of the state as a sovereign state, because human life is something which is getting a more amount of suffering from it and more amount of like dissing from it. And I think that becomes an important consideration point from that particular aspect. The other couple of points you can also raise from opposition, and I'm not dealing with this much more in depth because we are running out of time also a bit. But what opposition teams can say is that it's much more likely that military interventionism can create more problems because militaries can cause harm. There's a much better likelihood of economic sanctions and other policies or mechanisms which can have a much better effect of policy. And there could be a better place in which you are promoting the people of the state to themselves act against the commission of genocide and so on. So there are different ways in which you can approach this particular argument and particular like motion. And some of the examples which we have discussed previously would help you do this better as well. Now, how do these three fields talk to each other? Now, international relations, as we've discussed extensively, explains the political will or lack thereof to act, like a realist China will not act. International law, which is the rules, provides the legal justifications or barriers for the action. Like we act under the R2P, but China will use its sovereignty argument to veto us. Or the criminal justice models, where you define the philosophy of the action. And an example of this could be our goal is retributive justice via the ICC, not just rehabilitative aid. A good debater would try to use all of these three in terms of building a better argument in law, IR, or IL in terms of the motion fabric. Now, let's quickly go over some tips for judges and what judges are expected to do from legal motions. I think primarily when you're looking at legal motions, and as I mentioned this to all judges for everything in general, Be reasonable. Don't, and I know a lot of lawyers are usually debating, which means that you have specialized knowledge on certain aspects. You might be very critically aware about international law, international relations, or criminal justice, but that doesn't necessarily mean that that specific knowledge is accessible to the speakers in your room. So don't judge beyond what is being said in the room itself. That's one of the fundamental things that you need to be careful about. Secondly, always prioritize that you are looking at the case holistically in terms of what is being presented to you, not as to what you are building the case for. So if there is something which is lacking in terms of argumentativeness from one side and they're not fulfilling their burdens or not closing the arguments completely, do not assess those claims in the guise that those claims are complete or those claims are something that can be beneficial in terms of its application. So be very careful that you're addressing things only to the extent that they have been discussed. Be also careful that you don't fall into the impact trap or the righteousness trap. I think often in IR, IL, and CJ motions, something might appeal to you principally, but if that principle application is, or the principle itself is idealistic and not applicable in the state, you can't really give that principle credit because that principle is only idealism at that point. So be careful to check in your pitfalls and biases in terms of every reading of the motion, and also not to debate upon what you believe to be the right case or not. The second thing that I would probably, or the second aspect that I'll probably tell to judges about this particular thing is that law motions are hyper critical towards impacts as well as any motions in general. So, which simply means that law is talking about humans and human operations. It often deals with complicated aspects like psychology and how people react to certain behaviors and how tendencies of certain behaviors are, or what are the necessities for doing things. So, it often means that a lot of things would be debated in hypotheticals as to what is the probability or the likelihood of outcome of certain things in a state. What judges need to do is carefully look at what presentation happens for these hypotheticals, that these hypotheticals are not something which is just like left open ended, as to that presentation needs to have certain tangible meaning into what the motion dictates for you. So you have to be very careful that the teams are also, that you look at the teams identifying the burdens properly and using those hypotheticals properly. Like for instance, if I'm talking about a legal system which is catering towards preventing harm for some members of minority communities, I cannot look at this in terms of what it is in the world when it has not occurred yet. So if they're changing a policy, that would obviously mean that there are certain amount of modeling and hypotheticals that they will be proposing. So you have to be careful that you analyze those things which are being spoken by the speakers carefully. The next few general tips that I can probably have for judges is that be attentive, be nuanced. And since this is also like a BP, you have to be careful that you are noting things down and also be careful about understanding what essentially extensions are and how closing teams are operating within that room and within and around. So once you get a clearer picture of that and how you format discussions, you have to be careful in terms of giving credit where credit is due and to which team that credit is due. Don't discredit extensions solely because of this idea that those extensions are something that can have some origin there. Extensions can have genesis from the opening teams, but if they are uniquely argumentative and also like discussing unique impacts or unique benefits or unique framings, you have to still give credit to that particular team for that framing or uniqueness that they bring or the unique claim that they bring and so on. Be also very careful, and this is specifically for deliberation times for judges, that you manage deliberation times well. Don't ramble on by saying a lot of unnecessary stuff. Be critically acclimatized towards what is necessary and what is succinct and good to approach, or what is necessary to be said, and approach the things accordingly. So, yeah, I hope that helps both the speakers and judges as well in assessing. So, further discussions or further places where you can find some information from, I think couple of things I will give you caveats again. And since this is the end of the workshop nearly, these caveats are necessary. We have only briefly discussed these concepts. There is a lot more which is there. You will be good to spend some time, go through Wikipedia just to get a brief understanding. I know I'm recommending Wikipedia, but trust me, just to get like a general definitional aspect of things in a couple of paragraphs coalesced, and then go into the rabbit hole of reading different things from the links which are present in that particular page. It's a good resource. There are other couple of resources which you can read if you're very into like IR, IL, and CJ. You can go ahead and read the ICJ court papers, you can read the ICC court papers, you can read a lot of good material that is there from different blogs across the globe. I'll try to share some material with you at the end if possible. But yeah, more or less that should cover whatever different aspects you have in terms of discussions around it. But also, the other thing is that application is harder than theory. So even if you've heard all of these concepts and you have listened to this workshop for like an hour almost now, be careful that you actually go ahead and implement them. Without implementation, there's not going to be any change or necessary benefit that you're going to get from this. So try to practice as much as possible. So yeah, that brings us to a close of my presentation. If there are any questions, I'll be happy to take them, and then we can conclude. I'll also, like yesterday, drop my number on chat in case you're not comfortable asking questions now, or you want to ask questions later after thinking about it for a while. Please drop me a text on WhatsApp. Do not call, do not do a video call or anything, just a simple text, and I will get back to you at the earliest. Anyways, let's just see if there are any questions and wait a minute or two for them. I'll also drink some water meanwhile. Right. I don't see any questions, so I think it's okay for us to start wrapping up. DSM, I'll be handing it over to you. You can continue and wrap up.
Yeah, thank you so much, Kaushik, for such a wonderful and explosive session. Thank you so much for putting in so much into the resources and also availing materials as well. Thanks to everyone that also stayed through. For the judges who stayed through, you can be rest assured your data are being kept with me. Such also will be related to the cap for whatever decision they would have to make use with it. So the next session is coming up in the next 45 minutes. That's going to be the next session by Rahim, and I don't want you guys to miss it. So I think people can just take a break now, and by 6:45 p.m. GMT plus one, we are going to be having the next session today, and that will also be the last session for today. And then just to be clear, tomorrow we have three important events. The first, of course, tomorrow tournament starts officially tomorrow, but that will be specifically for the public speaking category while the debate training goes on. So tomorrow we have two workshops for debaters. One is going to be on adjudication, and the other one is going to be on speaking, which is winning from opening half, which is going to be taken by Prosper Michael and Ebube Anthony. Yeah, so just in those respective order. And then the third event we have tomorrow is the Masters round, which all judges are expected to judge alongside the adjudicators test. So you'll just watch out for that info on our platforms. Yeah, so thanks so much, guys. You can go take a break now, maybe take a break, take water or something. At 6:45 p.m., we would reconvene for the last session for today. Thank you so much, guys. And thank you once again, Kaushik.
Thank you, DSM, for having me. Thank you, everybody, for staying along. And if you have any questions, reach out to me whenever you want to. Take care. Bye bye.